Hey, welcome to today's video. I'm Richard Chapo. I'm an attorney in San Diego, California, and I've been advising online businesses for about the past 20 years. So today we're taking a look at ADA applicability to websites and apps. The ADA is the Americans with Disabilities Act. It is a federal law that was enacted in 1990. So what does the ADA do at its core? Well, it more or less prohibits discrimination on the basis of disability in places of public accommodation. So as you can see on your screen, we've highlighted places of public accommodation. What does that mean? Well, there's a good bit of argument over that. There is no specific definition in the ADA that certainly at least applies to the online environment. And in fact, when you read the ADA, what you find are standards required for businesses' physical locations and how they should accommodate disabled individuals. There's no mention of the internet. There's no mention of smartphones or apps or any of these kinds of things. No tablets, no nothing. And so some people have argued that because of that, the ADA should not apply to the internet. However, we do have to keep in mind that the ADA was drafted in 1990. Most people didn't know what the internet was in 1990. And so that argument hasn't always been as persuasive as it may seem. And to counter it, there's no actual language in the ADA which says that the law only applies to physical locations. And so, unfortunately, we don't really find an answer within the ADA to the question of applicability to the online environment. Instead, we have courts wrestling with the issue. And so what courts have diverged on some of their rulings in this area, but there's also some commonalities. So if we have a situation where an online business has a physical location, such as a store or something of that sort, and there's a nexus between the online platforms and that store, then the ADA is going to apply to the online platforms. Let me give you an example. Let's say I have a store selling men's ties. Probably wouldn't be very profitable, but let's just say we do. And it's in a mall. And then I have somebody develop a website and an app for me. And you can shop through my inventory on those two platforms, make orders, and so on and so forth. Well, clearly there's a nexus between those and my physical store because I'm selling, essentially the same things. You can take the same kinds of actions and what have you. And so in that situation, the ADA is going to apply to the website and the app. And the courts pretty much universally agree on this. Where things get a little more confusing, unfortunately, is in a situation where you have an online business that doesn't have physical retail space or areas where they're allowing customers or clients to come in. So if we think of maybe something like a dating site, a dating site might not be the best example. How about a blog? A blog where somebody is doing food recipes. Okay. Well, clearly in that situation, there is no physical location. And so then the question becomes, okay, well, without that physical location, do you still have to comply with the ADA? And this is the area where the courts start heading off in their own directions. The federal court system is made up of circuits of appeal, and the First, Second, and Seventh Circuits have said it doesn't matter if you have a physical location. You have to comply with the ADA if you have a website or an app. Now, the Third, Sixth, Ninth, Fourth, and 11th Circuits have said, no. You have to have a physical location. So we have a situation where in some courts they do require the physical location before the ADA will apply, and other courts where they don't. And that's not a good result. So we have a conflict in the courts, and it makes it very difficult for businesses to predict, the overall situation where they should comply or not, because there are costs and efforts involved in that compliance, and so it's a bit of a mess to say the least. Now, are there any solutions for this? Well, there are three potential solutions. One would be the Supreme Court would step in. The Supreme Court would come down, pick up one of these cases, hear it, and issue an opinion. And the opinion would basically say, yes, you need a physical location to be present before the ADA will apply to online platforms, or no, and just basically decide that. Once the court rendered that decision, all the circuit courts would have to follow it, regardless of their previous opinions. doesn't really seem like the kind of case the Supreme Court's going to be that interested in, to be quite honest. I mean, maybe they'll take it up, but of all the other hot button topics that are out there, this one doesn't really seem like it carries much weight. Instead, the problem that we have here is really one, personally, I would expect to be handled more from either a congressional or an agency perspective. So in this situation, the Justice Department is authorized to issue regulations for the ADA, and they never have. Not as it applies to the internet. Now, I want to say as far back as maybe 2011 that they indicated that they were going to, that they would certainly be issuing these, and this would help because the regulations would essentially say, here's how we're interpreting the law, here's what we're expecting to see, here are the guidelines that you either do or do not have to follow. And there would be much rejoicing because then businesses would have certainty. But the court or the Justice Department just hasn't done that. Every year they say they were going to do it, and then they wouldn't, and they would continue it to the next year. And then I think about 2 years ago, they just gave up the ghost and said, no, we're not going to issue regulations. So that's not helpful. So what about Congress? Can we expect Congress to come in and amend this law to address the internet issue? And the answer is, doesn't look like it. The kicker of this is Congress has actually come in and looked at the ADA seriously twice. In 2008, they actually did amend the law, but they amended it on other issues that were unrelated to the internet question. And then again in 2018, they came in and looked at it, but again, they didn't really address the internet issue. They were looking more at the question of basically loosening up the requirements of the ADA, if you will. And that act that they were trying to pass, it was approved and passed by the House of Representatives, but it was rejected by the Senate, and the bill died. So we are left at the current situation where it doesn't appear like Congress is going to act anytime soon, nor does it appear the Justice Department is going to get off its rear end and issue regulations. So we are left with a situation that is not great. If you are a business, you want to understand your obligations and the risk associated with those obligations and laws, and then, take whatever steps you choose to in relation to compliance. And here it's just very difficult to know what those steps require. So my suggestion is that you sit down with an attorney if you are having questions about the ADA and its applicability to websites and apps and whatever other online platforms you have in mind. This is not a LegalZoom issue. This is not something you wing it on because lawsuits are coming fast, right and left, and we see a lot of troll efforts here. And there are abusive lawsuits filed. You'll see one person files 50 lawsuits. And obviously, that's not necessarily applicable to what they're doing online. They're not really actually being harmed. And you have to wonder if some law firms are turning this into a profit center. Now, that doesn't mean there aren't legitimate cases. There absolutely are. And really, Congress and the Justice Department are doing a disservice not only to businesses, but to disabled people. We need an answer on this. We need some clarity because most businesses will comply if they know that they have to and they know what the guidelines are. Right now, we don't even have guidelines. We have suggestions that there are a couple different sets of guidelines out there that maybe you should follow. But, even the Justice Department has said you don't have to. And that those guidelines aren't necessarily binding. In fact, let me just give you kind of an example of just how crazed this has all become, particularly between Congress and the Department of Justice, so you can get a real feel for your tax dollars at work. So in September of 2018, 103 members of the House of Representatives sent a letter to the Justice Department discussing the ADA and the internet application. Now, this wasn't a political maneuver. It was a bipartisan group. So it wasn't a matter where Republicans or Democrats were trying to jab each other. And the letter said, that the group was requesting clarity on, quote, unresolved questions about the applicability of the ADA to websites, which have created a liability hazard that directly affects business in our states. So essentially the exact issue that we're pointing out here, that some courts have different rulings and businesses are really unable to predict what they're supposed to do in regards to compliance. And the Department of Justice responded humorously, with one of the great pieces of correspondence that is rather lengthy and doesn't really actually say much. So they said, quote, the department first articulated its interpretation that the ADA applies to public accommodations websites over 20 years ago. This interpretation is consistent with ADA Title III requirements that the goods, services, privileges, or activities provided by places of public accommodation be equally accessible to people with disabilities. Additionally, the department has consistently taken the position that the absence of a specific regulation, the regulation the department was supposed to issue, does not serve as a basis for noncompliance with the statute's requirements. Oh, Lordy. Absence of the adopting of specific technical requirements for websites through rulemaking, again, which the department was supposed to have done, public accommodations have flexibility in how to comply with the ADA's general requirements through rulemaking. So what they're basically arguing is, no, we haven't issued regulations. And this is actually a good thing because businesses now have flexibility to do, whatever they want to do in regards to compliance. Let's not shed any light on the topic. That's a good thing. Let everybody wander around in the dark. And then the final sentence kind of summarizes what's going on here. It says, given Congress's ability to provide greater clarity through the legislative process, we look forward to working with you to continue these efforts. So what we have here, in layman's terms, is Congress sending a letter to the Department of Justice, and they're saying, hey, DOJ, get off your butt, issue regulations, and provide clarity on this issue. And then we have the Department of Justice responding with, no, you get off your butt and amend the law so it's clear. So it's clear to businesses what the situation is with, the internet. And so we know Congress isn't about to do an amendment, and we know the Department of Justice isn't about to, issue regulations on this. And so nobody wins. And both the Justice Department and Congress should be ridiculed for doing this. This is just a horrible outcome. It's, as I like to say, your tax dollars at work. And so you don't have an answer. Does the ADA, is it applicable to websites and apps? Maybe. Depends where you live. Depends where your business is located. Depends on the nature of your business. Depends on whether you have a physical location, a store, what have you. There are a whole number of steps that you have to go through to make the determination. And in many cases, particularly if you don't have a physical location, the answer isn't going to be clear. So the best suggestion that I have seen is that you really need to sit down with an attorney and go through your business and try to come up with a plan for dealing with potential ADA complaints. Because lawsuits are becoming more and more frequent. Again, this is an area of abuse. There are plenty of legitimate ADA lawsuits brought by individuals who are disabled, but quite frankly, there's a lot of nonsense and people that are filing just to try to get quick settlements. So prepare thyself. Again, be proactive on this, not reactive, and I think you'll probably come out with a better result. So anyways, that's it for today's video, ADA applicability to websites and apps. If you have questions or anything, feel free to contact me. I'll be happy to answer them. If you are interested in learning more about legal issues associated with running an online business, feel free to subscribe to the channel, as I'll be discussing a whole variety of other topics. And most of those other topics will actually have answers. They won't be like this one where you're kind of left hanging. So I promise. Anyways, thanks again for watching, and have yourself a good one.